All right, if you're a junior practitioner or, you're deep in prep for the bar exams, especially in Queensland, you know that federal court practice can feel like you're walking through a minefield. But here's the secret. Getting these procedural rules down cold isn't just about dodging mistakes. It's about grabbing a massive strategic advantage. So let's kick things off with a classic scenario, one that gives every practitioner that sinking feeling in their stomach. You've just filed the originating application. You're feeling pretty good, and then you see it. A huge critical mistake. What do? This is where all that study meets the real world, and the rules become your absolute lifeline. So here's our game plan for today. We're going to walk through the playbook. We'll start with something pretty common, fixing the return date. Then, we'll dive into the really high-stakes world of constitutional matters, where a small mistake can have massive consequences. After that, we'll cover the super important power of amendment, and then we'll wrap it all up. Let's get into it. First up, the return date dilemma. This is a situation you'll definitely come across, but thankfully, it's pretty straightforward. It's all governed by one rule, Federal Court Rule 8.07. Let's get this one locked in. Okay, so Rule 8.07 gives you two very different paths, and you have to know which one you're on. If you filed electronically, it's easy. The registrar sorts it out for you. But, and this is the important part, if you filed any other way, the job falls right on your shoulders. You need to pay super close attention to Rule 8.07 Subrule 2. That's 8.072. It says that you, the applicant, must change the return date on the copy that you're going to serve. So the key takeaway here is simple. How you file dictates what you do next. Okay, let's build on that. We're moving from a simple fix to an area with much, much bigger consequences. Constitutional matters. This is a space where you have to be precise. The rules you need to burn into your brain here are Rule 8.11 and Rule 8.12. First off, what exactly are we talking about when we say constitutional matter? Well, Rule 8.11, Subrule 1, gives us the definition. It points us directly to Section 78B of the Judiciary Act. Basically, it's any matter that arises under the Constitution or involves interpreting it. This definition is the trigger. As soon as your case hits this trigger, a whole new set of obligations just kicks in. So you've figured out you have a constitutional matter on your hands. Now what? Well, Rule 8.11, Subrule 2, lays out 3 steps that are absolutely mandatory. You have to file a Form 18 notice, and in that form, you've got to spell out the nature of the issue and the specific facts that make this rule apply. This is not optional. It's a fundamental duty you have to fulfill. But why? Why all the extra work? What's the big idea? It really comes down to this core principle you see right here. There is a high public interest in making sure the Constitution is interpreted consistently. So that notice isn't just another form to fill out, it's what gives the Commonwealth and state attorneys general the chance to step in, because your case might be about more than just the parties involved. So does any mention of the Constitution trigger this whole process? No. And this is a really key distinction, especially for your exams. Section 78B of the Judiciary Act doesn't get activated if the point you're making is, as cases like C.G. Barbados holdings say, frivolous, vexatious, or an abusive process. There has to be a genuine, arguable question for this duty to even come into play. And of course, there are deadlines. You have to know the deadlines. Rule 8.12, Subrule 2 is your go-to for timing. So if the issue comes up in your originating application or a pleading, you've got 7 days from filing to serve the notice. If it pops up later, you have to serve it no later than 14 days before the hearing. These are hard deadlines you absolutely must know. Okay, let's switch gears to our final big topic, the power to fix mistakes and evolve your case as you go. This is where Rule 8.21 comes in. Honestly, you should think of this rule as one of the most powerful tools in your entire litigation toolkit. Under Rule 8.21, Subrule 1, the court has really broad power to allow amendments. And the reasons are pretty extensive. We're talking everything from fixing a simple typo to correcting the name of a party, all the way to something as big as adding a whole new claim for relief. This rule is your main way of making sure the real issues get sorted out. Now, you really need to zoom in on this subtle but critical difference between subrules C and D of Rule 8.211. Correcting a name under C is for a simple mistake. You meant to sue John Smith, but you wrote John Smith. Easy. But correcting an identity under D is way more complex. This is where that principle from bridge shipping comes in. You intended to sue the right person, like the auditor of a company, but you just got their actual identity wrong. Getting this distinction is so important. The stakes get even higher when a limitation period has run out. And here, the rules draw a very hard line. Under Rule 8.21, Subrule 2, the court may still let you amend a statute-barred claim if it all comes from the same set of facts. But, and this is a huge contrast, Rule 8.21, Subrule 3 is an absolute showstopper. If your new claim comes from facts that happened after the case started, you must not even apply after the limitation period is up. That door is slammed shut. So, from changing dates to notifying attorneys general to completely amending applications, we've seen just how much these procedural rules shape a case. It's pretty clear that knowing this stuff isn't just about passing an exam. It's the foundation of being a sharp strategic litigator from day one. So here's the bottom line. These aren't just dry, boring rules. They are the entire architecture of justice in the federal court. And knowing them inside and out is the difference between your case getting knocked out on a technicality and you actually getting the chance to fight and win on the merits. The only real question is, which side of that line do you want to be on?